Mode of revision. Section 256. Amendments to Constitution. How proposed and voted upon. Amendments to this Constitution may be proposed in either House of the General Assembly at a regular session, and if such amendment or amendments shall be agreed to by 3/5 of all the members elected to each House, such proposed amendment or amendments, with the yeas and nays of the members of each House taken therein, shall be entered in full in their respective journals. Then such proposed amendment or amendments shall be submitted to the voters of the state for their ratification or rejection at the next general election for members of the House of Representatives. The vote to be taken therein in such manner as the General Assembly may provide, and to be certified by the officers of election to the Secretary of State in such manner as shall be provided by law, which vote shall be compared and certified by the same board authorized by law to compare the polls and give certificates of election to officers for the state at large. If it shall appear that a majority of the votes cast for and against an amendment at said election was for the amendment, then the same shall become a part of the Constitution of this Commonwealth, and shall be so proclaimed by the Governor, and published in such manner as the General Assembly may direct. Said amendments shall not be submitted at an election which occurs less than 90 days from the final passage of such proposed amendment or amendments. Not more than 4 amendments shall be voted upon at any one time. If 2 or more amendments shall be submitted at the same time, they shall be submitted in such manner that the electors shall vote for or against each of such amendments separately, but an amendment may relate to a single subject or to related subject matters and may amend or modify as many articles and as many sections of the Constitution as may be necessary and appropriate in order to accomplish the objectives of the amendment. The approval of the Governor shall not be necessary to any bill, order, resolution, or vote of the General Assembly, proposing an amendment or amendments to this Constitution. The current Constitution is the first Kentucky Constitution that may be amended without calling a convention. The delegates speculated that the framers of the previous constitutions did not include an open clause allowing piecemeal amendment because they feared that slavery might be abolished or otherwise compromised by such an amendment. They believed that it should be possible to change the current Constitution by specific amendment as an alternative to replacing the entire charter with a new one drafted by a constitutional convention. However, they did not want to make the process too easy for fear of encouraging trivial amendments and lessening respect for the document, so they limited to 2 the number of amendments that could be voted on in a single general election. They also specified that an individual amendment could only deal with one subject and that if the voters rejected an amendment, it could not be proposed again for 5 years. By 1929, legislators had come to believe that the 2-amendment rule delayed needed constitutional revision. So they proposed an amendment that would entirely abolish that limitation. The voters rejected this and 3 other similar amendments before finally approving a more conservative amendment in 1979 that permitted as many as 4 amendments to be voted on in a single general election. The amendment also provided that a single amendment could deal with more than one subject and could amend or modify as many sections of the Constitution as needed to accomplish the objectives of the amendment. It also deleted the prohibition on resubmission of a failed amendment within 5 years. Proposed amendments must be submitted at the next general election for legislators and cannot be postponed until a later election, in Herod v. Hatcher, 1940. An amendment repeals all inconsistent provisions of the Constitution even if an express statement to that effect is not included in its language, in Funk v. Fielder, 1951. When 2 sessions of the General Assembly held prior to a general election propose more than 4 amendments, the first 4 shall be voted upon.
Section 257. Publication of proposed amendments. Before an amendment shall be submitted to a vote, the Secretary of State shall cause such proposed amendment, and the time that the same is to be voted upon, to be published at least 90 days before the vote is to be taken thereon in such manner as may be prescribed by law. The purpose of this section is obviously to ensure that the voters have an opportunity to read and consider proposed amendments before they vote on them. The Kentucky judiciary invalidated an amendment approved by the voters because it had not been publicized 90 days prior to the election as required by Section 257 in McCreary v. Speer, 1914, and ordered another proposed amendment taken off the ballot because it had not been publicized according to the requirements of Section 257 in Arnett v. Sullivan, 1939. Section 258. Constitutional Convention, how proposed, voted upon, and called. When a majority of all the members elected to each house of the General Assembly shall concur, by a yea and nay vote, to be entered upon their respective journals, in enacting a law to take the sense of the people of the state as to the necessity and expediency of calling a convention for the purpose of revising or amending this Constitution, and such amendments as may have been made to the same, such law shall be spread upon their respective journals. If the next General Assembly shall, in like manner, concur in such law, it shall provide for having a poll opened in each voting precinct in this state by the officers provided by law for holding general elections at the next ensuing regular election to be held for state officers or members of the House of Representatives, which does not occur within 90 days from the final passage of such law, at which time and places the votes of the qualified voters shall be taken for and against calling the convention, in the same manner provided by law for taking votes in other state elections. The vote for and against said proposition shall be certified to the Secretary of State by the same officers, and in the same manner as in state elections. If it shall appear that a majority voting on the proposition was for calling a convention, and if the total number of votes cast for the calling of the convention is equal to 1/4 of the number of qualified voters who voted at the last preceding general election in this state, the Secretary of State shall certify the same to the General Assembly at its next regular session, at which session a law shall be enacted calling a convention to readopt, revise or amend this Constitution, and such amendments as may have been made thereto. The first Constitution bypassed the legislature and provided for the direct submission of a convention called to the voters in 1797 and, if a majority approved, again in 1798. If either referendum failed, then 2/3 of both houses could call a convention. The second and third constitutions provided that a majority of all the members of each legislative house had to approve a convention call referendum, and a majority of all the voters entitled to vote for representatives had to approve a call in 2 successive referenda for a convention to be convoked. Section 258 provides that if in 2 successive sessions a majority of all members of each house approve a referendum, it shall be held at the next general election for state or legislative candidates, and if a majority of voters equal to 1/4 of those who voted in the preceding general election so approve, the General Assembly shall call a constitutional convention. Voters have rejected 4 convention calls since the adoption of the current Constitution. In 1964, the General Assembly authorized a Constitutional Revision Assembly to propose a new constitution to the voters, who rejected it overwhelmingly in 1966. Before that vote, the Kentucky Court of Appeals ruled that Sections 256 and 258 did not provide the only ways of changing the Constitution, and that the legislature had constitutionally created the Constitutional Revision Assembly, in Gatewood v. Matthews. 1966. The court also ruled that Section 258 did not prohibit the General Assembly from attaching a condition to a convention call referendum, in Gaines v. O'Connell, 1947, and that Section 258 did not prohibit a special session of the General Assembly from authorizing a convention call referendum, in Chenault v. Carter, 1960.
Section 259. Number and qualifications of delegates. The convention shall consist of as many delegates as there are members of the House of Representatives, and the delegates shall have the same qualifications and be elected from the same districts as said representatives. A similar provision can be found in the previous constitutions. The framers of the current constitution rejected a proposal that the number of convention delegates be reduced to 38, the number in the state Senate, because they believed that 100 delegates, the number in the House, would provide a better representation of public opinion. There have been no published decisions concerning this section. Section 260. Election of delegates, meeting. Delegates to such convention shall be elected at the next general state election after the passage of the act calling the convention, which does not occur within less than 90 days, and they shall meet within 90 days after their election at the capital of the state, and continue in session until their work is completed. Each of the previous constitutions contained a similar provision. The Kentucky Court of Appeals ruled that a November election at which voters would elect presidential electors would constitute a general election as specified in Section 260, in Chenault v. Carter, 1960.
Section 261. Certification of election and compensation of delegates. The General Assembly, in the act calling the convention, shall provide for comparing the polls and giving certificates of election to the delegates elected, and provide for their compensation. This section was obviously designed to validate the election of delegates and to provide for their compensation. No decisions concerning this section have been published. Section 262. Determination of election and qualifications of delegates, contests. The convention, when assembled, shall be the judge of the election and qualification of its members, and shall determine contested elections. But the General Assembly shall, in the act calling the convention, provide for taking testimony in such cases, and for issuing a writ of election in case of a tie. The Third Constitution contained a similar provision to ensure a process for the resolution of disputes about the elections and qualifications of delegates. There have been no decisions about this section.
Section 263. Notice of election on question of calling convention. Before a vote is taken upon the question of calling a convention, the Secretary of State shall cause notice of the election to be published in such manner as may be provided by the act directing said vote to be taken. This section is obviously designed to ensure that voters are given notice about any pending election at which the question of a convention call is to be voted on. The Kentucky Court of Appeals held that the failure of the General Assembly to provide for publication of a notice of a convention call question did not invalidate the statute directing that the question be placed on the ballot in a case where the Secretary of State published such a notice 78 days before the election was to be held, in Gaines v. O'Connell, 1947. Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution by Robert M. Ireland, Oxford University Press.